Good afternoon, everyone. Thank you for joining us for today's Lunch and Learn. I'm Lauren Smith with the International Franchise Association, and we have a great 30 minutes lined up for you. Before we begin, I would like to remind everyone that we are recording today's webinar and will make it available later this evening on community.franchise.org. If you have any questions for today's speakers, please add them to the chat box and they will be addressed toward the end. Today's topic is Trademark Triage, Protecting Your Most Valuable Asset, and it is brought to us by Saxton Stump. Here to provide today's discussion is Thomas J. Kent Jr. and Kelly Tillery. Thank you all for joining us today, and thank you to Saxton Stump for sponsoring today's Lunch and Learn. I'll go ahead and turn things over to you.
Thanks, Lauren. Good afternoon, everyone. My name is Tom Kent. This is my colleague, Kelly Tillery. We're here to present Trademark Triage, Protecting Your Most Valuable Asset. I'd like to thank the IFA for hosting this today, and thank you for all attending. As a brief introduction, if we could, there we go. As a brief introduction, Kelly and I are shareholders with the law firm of Saxton Stump. We are a full service firm with practice areas including franchise law, intellectual property, and litigation, among many other things. You go to the next slide, Lauren. So I've been a franchise attorney for about 25 years. I started in-house with an international franchise company, and today work with a team of experienced franchise attorneys. We focus on franchise litigation, intellectual property matters, franchise regulatory matters, and mergers and acquisitions. Go to the next slide, Lauren. Go.
I am Kelly Tillery. I've been a shareholder here for about 6 or 7 months. Prior to that, I've been practicing law for about 43 years. I've been handling trademark and other intellectual property cases, particularly injunctions, since about 1980, when I first handled the matter for Black Sabbath after they'd thrown out Ozzy Osbourne for his drug and alcohol problems. Since then, I've been handling cases around the country, trademark infringement matters for a variety of industries.
Great, Lauren, next slide, please. So before we get into the actual trademark triage conversation, wanted to talk a little bit about why franchisors should be looking to protect their trademarks. As we all know, franchisors invest a tremendous amount of time, energy, and money to establish their trademarks and to build goodwill around those marks. In a franchise relationship, of course, those trademarks are licensed from the franchisor to the franchisee, and the franchisee is required to use the marks exclusively in connection with their franchised business. The franchisor has an obligation to the franchisee to protect and defend the marks that they've licensed. Those obligations are rooted in contract. A failure to protect the marks that the franchisor owns may in fact create a cause of action by the franchisee against the franchisor. So at the fundamental level, we have a contractual obligation where the franchisor owes that duty to its franchisees to protect the marks that it has licensed. Now, apart from the duty created by the franchise agreement, courts have held that a franchisor or a trademark owner has an affirmative obligation to protect the mark. And we're going to discuss that a little bit now. We can go to the next slide, please. So this is an interesting case, Chattanooga Manufacturing v. Nike. This was a case where Chattanooga Manufacturing, which was founded in 1979, was a manufacturer of women's clothing. In 1985, Nike launched its Jordan brand, the most famous of which Air Jordan, which unless you live under a rock, you've heard of. In 1998, the USPTO granted trademark registration to Chattanooga for Jordan in connection with its ladies' clothing line. In 99, Nike briefly used the Jordan mark in association with women's apparel. Previously, the Jordan mark was only used with boys and men's shoes, athletic apparel, and so on. So in '99, Chattanooga sued Nike and Michael Jordan, alleging trademark infringement and unfair competition in violation of the Lanham Act. So the court in Chattanooga wasn't buying what Chattanooga was selling, and Chattanooga's trademark infringement claims were barred. The court found Chattanooga had constructive knowledge of the alleged infringement as early as 85, when Nike launched its national ad campaign. Chattanooga delayed bringing suit for 9 years, which was 3 times the length of the statute of limitations. And the court said, therefore, it was presumptively unreasonable for Chattanooga to pursue a remedy in that case. Further, the court believed that Nike would be prejudiced if it were required to pull down its product line after investing millions of dollars around the Jordan brand. So really what we take away from the Chattanooga case is those who sleep on their rights lose them. A trademark owner is chargeable with information it might have received had due inquiry been made. So we see the court confirming that the trademark owner has an affirmative obligation to protect the trademark, and that obligation extends to reasonable investigation of others who may be using the same or similar marks related to products that are the same or similar to those of the trademark owner. It's important for franchisors to remember that registration of the trademark is really the first step in this process. It doesn't end upon registration. The entire process is from registration to protecting throughout the life of that trademark. And Kelly, I know you're familiar with the Chattanooga case, and do you have any thoughts around the court's holding here?
I believe it was certainly the correct holding, even though I believe knowledge that I've represented Nike before, although not in that case. Generally, the rule is anything under 6 months. If you wait under 6 months to take action of an infringement, you're not likely going to be refused a preliminary injunction because of that delay. Anything between 6 and 12 months, you're also not likely to be thrown out of court on a preliminary injunction. However, anything more than about a year, you're in serious trouble of not getting a preliminary injunction. Doesn't mean you won't get a permanent injunction, but you're not going to get a preliminary injunction, which of course is the enormous hammer you have over the head of any alleged infringer.
So for franchisors, I mean, ignorance is not bliss when it comes to, who's out there using a mark that is either identical to, like, Chattanooga and the Jordan mark, or similar to your own mark, and in connection with services or products that are similar to those of the trademark owner. So if we can go to the next slide, please. So we've established that the trademark owner, and in this case franchisors, have an obligation to protect and defend their trademarks, whether it's by virtue of contract or by well-established case law. So now we turn to how a franchisor can protect its marks. And again, avoid the trap of falling into indifference. We need to stay vigilant. And one of the ways that a trademark owner and a franchisor can stay vigilant is to initiate a trademark policing program. We assist our clients with trademark policing programs routinely. We counsel franchisors on ways that they may create a policy around trademark policing. This is something that can be done in-house by a franchisor if they have the bandwidth and the capabilities to routinely examine what's out there that may be an infringing use. It can be things as simple as doing a Google search of your name, of the trademarks that you own, or slogans that you use in connection with your trademark. As simple as reviewing the USPTO database, which is a database that's relatively simple to search. Any person can do it. It's generally available to the public. In the case of a franchisor should be educating its franchisees around the subject matter, meaning alert your franchisees, make sure they know that if they discover a company in their market that's using something that looks similar to the mark that they've been licensed, or maybe the same as the mark that they've been licensed, the franchisee needs to know that they should be alerting the franchisor to the existence of that mark, so that the franchisor can make a decision if in fact it needs to take protective action to defend the mark and to protect the goodwill associated with the franchisor's brand. Some of our clients will engage third-party search firms to institute a policy where searches are done on a regular basis, sometimes quarterly, sometimes biannually. The search firm will create a report that is provided to the franchisor. Oftentimes our clients will send us those reports and we'll go through them, because depending upon the mark, there could be hundreds of hits on that report, some of which are going to be companies that are doing something entirely different than what the franchisor may be, their system may be based upon. But counsel can assist really assessing the risk associated with a mark that may be out there being used in commerce at the same time that your trademark is being used in connection with your franchise system. And I'd say the most important part of this policing program is it needs to be a disciplined approach, meaning this isn't a once in a while thing, because it's very easy to let the trademark policing fall to the wayside, because if it's not thrown in your face, sometimes you just don't know. So you have to go out and proactively search for marks that may be out there, for companies that are using phrases or using things that could be confusingly similar to your trademark. Because as Kelly just pointed out, you don't have a long period of time in which to effectively bring action to protect your trademark. So it's got to be something that you're out there doing systematically to identify infringing uses and to challenge them. On the flip side, if you do identify, an infringing use and you send out a cease and desist letter, that can't be the end of it, because if that cease and desist letter simply gets ignored by the company that you believe to be an infringing use, and you don't pursue a remedy beyond a cease and desist letter, that's not going to help your case. And in fact, it's going to hurt your cause. So it is a decision that needs to be made carefully in terms of when one should pursue litigation around trademark infringement, and understanding how marks may be used and what services or products those marks are being used in connection with, because that ultimately goes to the decision of whether or not we're going to pursue a trademark infringement claim on behalf of our client. And I guess, Kelly, I'd turn it over to you at this point and say, if we've gone through the process and we've said, okay, we think we've identified an infringing use and there may be something out there, how are we going to counsel the client, and what are, the thoughts that you would have around the trademark triage for the client?
Well, when all else has failed, when all those wonderful things that you and your client have done to protect your trademarks have failed, that's when you call me, and I've got a chopper waiting, and a team of people are going to get on that and do the triage to protect your family jewels. As I said, I've been doing this since 1980. Probably secured 300 to 400 in preliminary injunctions, or defended against probably equally as many. Trademark injunctions have been issued for 185 years. First one was done in 1838, Millington versus Fox. And contrary to popular belief, I was not counsel of record in that case. I have earned every one of these gray hairs in those injunction proceedings, but not that long. Seeking an injunction in a federal court, and that's where we prefer to be at all times for a variety of reasons, is time consuming and expensive. If you've ever been involved in regular litigation, you know that litigation can cost a fortune and last for years. That does not have to be true in trademark infringement litigation. One of the beauties of a trademark is that it is intellectual property. It is an intangible asset. It is something that is very difficult to quantify in terms of value, and it's difficult to prove to a court how much damage has been done to it by an infringer. And under those circumstances, courts make available to you extraordinary relief to stop infringement because it's so important and the damage is so hard to quantify. Under those circumstances, you can go to court immediately, seek a temporary restraining order and or a preliminary injunction, and get lots of additional extraordinary relief. So the litigation that would normally take a team of lawyers and 2 or 3 years and hundreds of thousands of dollars can sometimes get crammed into a period of 2 days or 2 weeks, or maybe 30 or 60 days, a short period of time before a preliminary injunction hearing. So you have to get all of your ducks in line, both your law, your facts, witnesses, etc., and put on a case to prove that you are entitled to the relief you're entitled to. And you have to prove that to one human being. There are almost 700 federal judges in this country now. And when you stand before one, the burden is rather high to prove that you're entitled to an injunction because it is an extraordinary relief. There are 16 maxims of equity. The first one and most important one is equity does what should be done. And my job on your behalf before a judge is to show that the judge should issue an injunction to stop infringement immediately. There are lots of kinds of extraordinary relief you can get. Not only can you get an order from the court to stop the bad guy from doing what he or she is doing, you can get expedited discovery. You can require that bad guy to produce documents and stand for depositions in a short period of time. You can get an order of seizure to seize the infringing goods or to stop the marketing that's being done, seize them. There are actually 4 kinds of injunctions you can get. One is a preservation injunction, which would be to preserve the current circumstances, which may or may not be in your interest. The second is a prohibitory injunction, that is to prohibit a defendant from doing something. The third is a mandatory injunction, which is extremely unusual, especially unusual in a preliminary injunction stage, because that requires someone to do something affirmative, like to take some steps to hire somebody or fire somebody or destroy some building or something like that. That's extraordinary. And then there's something called a therapeutic injunction, little known and not so often used, but very effective in trademark cases, because sometimes you can make a bad guy stop doing what they have been doing that is clearly illegal, but also stop doing some things which are just on the borderline. What is very effective about seeking an injunction is you can get immediate relief in a very short period of time. You get to address the judge ahead of everyone else. You get to go to the head of the line. You don't have to wait 6 or 8 or 10 months to see a judge. You get to see one immediately, and that can be very effective. However, when you get there, you got to be able to prove your case. And as lawyers, we play the hand that we're dealt. So we need to work very closely with guys like Tom and the client who have that information readily available to us, the litigators, to go to court immediately to prove 4 things. 4 things you have to prove. Next slide, please. 1, likelihood of success on the merits. That is the number 1 thing you have to prove. It's the most important thing. You have to prove that you own a valid trademark, that a defendant has used that or is using that trademark without your consent. And 3, and most importantly in this factor, is that you have to prove that that use is likely to cause confusion. And there are 10 factors at least. In the 3rd Circuit, they're called the lap factors. They're called other things in other circuits, but they're essentially the same. You have to prove that consumers are going to be more likely than not to be confused as to the source or affiliation of the goods and services to which the mark is affixed by the use by the defendant. And that can be proven by a number of ways: evidence of actual confusion, a survey, and a variety of other things. But that's the most important thing you have to prove in an injunction proceeding. Second is irreparable harm. Up until 2006, irreparable harm was presumed for a mark that was valid and in use. In 2006, the U.S. Supreme Court in eBay versus Mercantile Exchange changed the law. And between 2006 and 2020, which was kind of the wilderness for the practice of injunction law in my business, you had to prove irreparable harm, and sometimes that was difficult to do. The Trademark Modernization Act of 2020 was passed in 2020, big surprise, and that reinstated the presumption. So if you have a registered mark preferably, or even a mark that's used and valid, you have a presumption of irreparable harm. The other three things you have to prove is that the balance of the hardships weighs in your favor, such that if an injunction were issued against the defendant, it would cause less harm to him than it would to you. That's usually not an issue in most cases. And lastly, the public interest. Federal courts, many courts don't want to issue orders that are not in public interest. Generally, the law says that enforcing trademark law and or contracts and ownership of intellectual property is in the public interest, so courts want to do that. It's rare that that comes into play. Next slide, please. It's important to have an economical and effective enforcement program, and you need to be aggressive, but you need to be measured. You need to design an enforcement model, as Tom was talking about, and because there are different kinds of bad guys out there. There are terminated franchisees, which are bad guys, but oftentimes they were in the past good guys, and they're actually easy to stop, relatively so. There are imitators who are not flattering you by copying you identically. They can be stopped as well. And then what I call nibblers, those are people who come on the edges of your trademarks and intellectual property. They need to be stopped as well. As Tom indicated, you need to monitor the marketplace and be ever vigilant, because if you're not, it will be held against you at any time in the future where you want to enforce your trademark. I always tell clients you need to have a measured response, and I call it having an iron fist in a velvet glove. You need to decide how bad the infringement is, what the real risk is to your business, and what the best way to handle it. Sometimes a business-to-business solution is the best. You have a marketing guy call up his counterpart at the other company and say, what are you doing? Why don't you stop it? Sometimes you have CEOs call, sometimes GC to GC. It does not have to be escalated immediately to outside counsel. Cease and desist letters are probably the first step after that. Then there's a range of options from filing a lawsuit to filing a motion for a preliminary injunction, the seizure orders, et cetera. There's a whole range of options, all of which have different pros and cons and different costs. There are a number of things to avoid in these actions that are very important. One is, and this is a Latin phrase, de minimis non curat lex. It was a favorite phrase of my father. I learned when I was a little boy. It means the law does not bother with trifles. So do not bring a minor petty case to a court, because courts are not going to bother with it. The straight face test, there was a Judge Will in the Northern District of Illinois who always said no lawyer should make an argument that he or she cannot keep a straight face making. So please don't make me go to court making an argument that I can't keep a straight face making. The Streisand effect is something you may have heard of. Years ago, Barbara Streisand had this incredibly multi-million-dollar, beautiful mansion in Malibu up on a cliff, and some wise guy with a website put a picture of it on his website. Apparently she found it, and that upset her terribly, and she had her enormous law firm lawyers file a great lawsuit against this poor little guy and his website. On the day that she had filed the lawsuit, 6 people had visited the website, 2 of whom were the lawyers. Within 30 days after that lawsuit was filed, there were 400,000 hits to the website. The Streisand effect is, be careful what you ask for. Sometimes you're going to step in a pile of something you don't want to step into when you do this. A concomitant of that would be what I call the Joe Kennedy rule. Joe Kennedy, the father of Jack Kennedy and Robert Kennedy and Teddy Kennedy, always told his sons, he says, do not put anything in writing that you would not want to see tomorrow morning on the front page of the New York Times. And likewise, do not write even in an email or a letter, a cease and desist letter. And I will tell you, I will never write a letter that I will not that I would be embarrassed to see on the front page of the New York Times, or more importantly, in the hands of a federal judge when a lawsuit comes up. So every time I write anything, no matter how strong it is, I always tone it down because I realize it's going to end up on the desk of a judge at some point. So you need to be careful. And lastly, be conscious of what we call trademark overreaching or bullying. Nobody likes a bully. And if you write a bullying letter to a little guy, it's going to end up on the internet and you're going to be embarrassed by it. So you need to be very careful, and you may see some samples of cease and desist letters all on the internet that meet those requirements. Next slide, please. When you're doing this, you need to act very wisely and avoid claims and counterclaims, because defendants get lawyers too, and sometimes smart lawyers. And you need to avoid those counterclaims, but also claims against yourself for using someone else's intellectual property. After 40 years, I've distilled 3 fundamental rules there. Do not reap where you have not sown. You may think that's familiar, and it is. It appears at least 8 times in the Bible, in Luke, Matthew, and John, and another higher authority, the U.S. Supreme Court in 1918 referred to reaping where one has not sown. That's a pretty fundamental principle of intellectual property law. 2, ask permission before you use somebody else's IP, not forgiveness after, because trust me, forgiveness after is a lot more expensive. And 3rd, don't mess with the mouse, Disney. And that's a good story here. I represented Disney many times. Many years ago, Disney decided that they were being ripped off left and right, that they were essentially an intellectual property company, and they had to stop it. So they made a concerted effort. They decided to spend a lot of time and a lot of money suing and threatening to sue hundreds and hundreds and hundreds of people all around the country in order to, not to get relief specifically from them, although that was certainly in the mix. They wanted to get a reputation. And boy, did they get a reputation. And they got a reputation such that don't mess with the mouse. People know what that means. People don't infringe Disney very much anymore. If they're thinking about infringing anybody's intellectual property of a company like Disney, they'll go to Warner Brothers or to Saban or someone else. In your own industry, it can be very helpful to be known as the person not to mess with in terms of intellectual property. Next slide, please. Recently, you may have seen some information about the April 17, 2023 report of the FTC and GAO. Some people have said it's the sky is falling. I think they're kind of like Chicken Little because the sky is not falling. The elements that are put in that FTC report, at least 3 of the 5 that they identify, at least implicate trademark law to some extent. My own impression is that those, even if they were implemented in terms of legislation, would be very difficult to overcome the obligation of a trademark owner under the Lanham Act to protect his or her trademark by way of quality control. Quality control is the sine qua non, without which not you have to protect your own mark. It can be the tail that wags the dog in litigation. I'll give you one brief example. I represented a large university which had a hospital. It contracted with someone else to run it for many years. The running of it was not going so well. They realized they had entered into not a very good contract, and they wanted to be able to get out of it, or at least increase the quality of the services that were being rendered in their hospital. And when I examined their 50-page contract, I realized it was an awful contract entered into years ago when they were in a different situation. But there was one clause in it, which was their saving grace, and that was the quality control clause. A fundamental aspect of the deal was that the company they hired was allowed to use their trademark, which was valuable. And as a trademark owner, they were entitled to enforce and protect the quality control, and that gave them the upper hand. So quality control in a relationship of licensor to licensee is the absolute, it's what I call the kill shot. Remember that, next slide, please. Extraordinary relief is available, and it's only limited by the creativity of your lawyers and your needs, and of course the limits of the judge. I always love this quote by J. Paul Getty, who at the time was probably the richest man in the world, owner of Getty Oil Company. Don't tell me I cannot do what I want to do. Tell me how I can do what I want to do. J. Paul Getty, like many other business owners, got very tired of his lawyers being naysayers and saying I can't do something. In that regard, I will leave you with my tips for successful trademark litigation. The next slide. By the way, you'll notice that Tillery's has an R in the circle. That's because my name is actually a federally registered trademark. Don't mess with Tillery either. And finally, the 5 points, this is just, again, distilled from years of litigation. Staffing for injunctions. You need a lean team, you need a general, you need a lieutenant, and you need a couple of minions. You don't need 20 lawyers to do this. 2, our goal would be a timely, economical, and favorable conclusion, and those all have to be balanced appropriately. 3, from day one, you've got to find the kill shot. Have after doing this for a long time, hundreds and hundreds of cases, I will have to say that virtually every case has a kill shot. And while most lawyers eventually find that kill shot, sometimes when it's too late and they're shot in the head with it, you need to look for it from day one because it's there. It may be a piece of evidence, it may be a document, it may be a legal doctrine, it may be a witness, but it's there. It's something that can win the case and win it early. 4, you need to implement innovative strategy and tactics. I don't really like the expression thinking outside the box, but I can never think of another expression that says it that well. There are many ways to accomplish the result for a client in extraordinary relief cases. Early motions for summary judgment, seeking a preliminary injunction, declaratory judgment action, deciding where you want to sue, who you want to sue. There are lots of creative, interesting ways of getting the relief or telling the client how they want to do what they want to do. And then finally, you need to explore early and creative settlement options. There are many ways of doing that. Sometimes too many clients and lawyers get emotionally involved in litigation until they start getting their bills, and then they realize that they should be talking settlement. You should be thinking about that from day one, and that includes at an injunction hearing. There are business-to-business solutions. There are business solutions between parties. There are lots of results. I'll give you I'll leave you with one example of a settlement. I had two parties in a giant trademark dispute. Very wealthy entrepreneurs, each one who had built their own businesses. And when that happens, they think those businesses are their babies. One on the East Coast, one on the West Coast. They would not meet with each other at their respective offices. So we met in the middle of the country in Chicago. They ended up being about $50,000 to $100,000, about $100,000 apart in settlement. One guy refused to give the other guy that $100,000, not because he couldn't afford it, but he didn't want to give him the satisfaction. The other guy wouldn't take any less. I realized that both men were very supportive of their faiths and had donated enormous amounts of money. They were of different faiths, but they donated lots of money, charitable donations to their various churches. And I suggested that the settlement be done by a payment of $100,000 by the guy who didn't want to give it to the other guy, that he would pay it to his favorite charity. So it turned out my client was delighted because he paid the $100,000, but he didn't give it to the other guy. The other guy was delighted because he made my guy pay it, even though he didn't want it. He didn't care. He got it to his charity. So again, it was just a creative settlement of a dispute where there was some emotion involved. But the short, and I'll end it with this, is that extraordinary relief is possible if you get your ducks in line and seek relief immediately and do it in a measured way. Thank you. We have some questions. Lauren?
Thank you. It doesn't look like there's any questions in the chat yet. We can maybe give everyone a minute or so just to make sure they don't have any questions.
Let me ask Tom. I know, Tom, you had a recent experience with litigation. Maybe you want to say something about that and how frustrating that can be sometimes. It doesn't always go as smoothly as I may have indicated it does.
We do have a matter that's going on currently that Kelly's aware of, and we have a former franchise owner who was terminated, who continues to utilize our client's trademark in connection with the same type of business that he was operating as a franchisee. This individual is unrepresented. So we have really, I think, done everything possible to protect our client's marks. We've filed a complaint after he was terminated. We filed for injunctive relief in federal court. We have a situation where a federal judge is giving tremendous deference to this defendant because he's not represented. So it's been a frustrating process. We don't have any other reason or aware of any other reason why relief has not been granted to date in a reasonable time frame, other than the individual is unrepresented. So the process is there. The process is working through. We will get the result that our client is looking for. The time in which it's taking to get that result has been frustrated because we've got a pro se litigant, and I'm sure you've been in those circumstances where, courts give great deference to those types of individual defendants. And from the attorney perspective, it's very frustrating because we know we have the facts in our favor, we know the law in our favor, and the judge is really slow rolling this because I have an unrepresented defendant.
And that's oftentimes a problem. One of my favorite experiences was being before the Honorable J. Ernest Tidwell in Atlanta many years ago in a case I believe was for Bruce Springsteen, I believe. We were suing unknown defendants because there was people who were selling merchandise in the vicinity of Mr. Springsteen's concerts. And so at the moment, there were various John Does and Jane Does and ABC companies. And oftentimes in those cases, judges bend over backwards, as Tom said, because they want to make sure that the defendants have adequate due process. And as lawyers in those cases, you always want to tell the court that you are also very sensitive to the due process of those unrepresented, in those cases, unpresent defendants. And the Honorable J. Ernest Tidwell, in his inimitable way, leaned down to me and said, "Son, this is all the process they're due. Where do I sign that order?" And he signed my order. So sometimes it works.
We're open.
Looks like we had one question come in the chat. How would you recommend navigating accidental use of our franchisees of a different brand's IP? We originally split from a company in another country and now only share a name. Occasionally, someone may see our old IP on social media and may be tempted to use it. Advice on policing our own franchisees in regards to compliance here.
Well, I mean, if we're acknowledging that this is an inappropriate use of another's intellectual property and it was accidental, I'd recommend that the client should proactively reach out to the owner of the mark and say, we're not looking for trouble here. We're trying to navigate this. This was something that if it was accidental, it was accidental. So that should be a business solution in my mind. And oftentimes hitting those head on are the best way to address those situations. Kelly, have you had experiences with that type of use?
Yes, I think there is no substitute in cases like that for a good mea culpa. An apology in life is oftentimes the best way to take the wind out of someone's sails. And I think that's also true, especially if it's early on and nobody's lawyered up yet or filed lawsuits or anything like that. So acknowledging your error and apologizing for it. And sometimes, I mean, I've had cases where we resolved cases by me recommending, and I can think of a particular case, I can't name the client now, but two enormous drug companies fighting about something, and marketing people made a serious mistake identifying a drug with a name that was of the other company. And it went out to hundreds of thousands of docs. It was a serious error. We immediately caught it, we immediately stopped it. And of course, the other side lawyers wanted to have us pay millions of dollars. Well, I had the CEO of our client pen a handwritten private note, hand delivered to the CEO of the other company, apologizing in a very sincere way, handwritten, and asking for forgiveness. And the guy called up 10 seconds after he got the note, and it was done. So there's no substitute often for a good apology, a sincere one anyway. Hope that answered that question.
Great. We have just one more, and then this is going to be the last one we have time for. When a company starts the federal registration process and a search discovers a couple unregistered names used by businesses only in a local market, would you talk a bit about your options when you have the federal mark registered?
When you have it registered, I guess. Do you have a registration already for the mark and someone else is using it locally? That's the question. Well, let's assume that.
Well, if you own the mark and you discover uses of the mark or something similar to it, certainly you're going to address that head on with the user of the mark or the potentially infringing use. if the question is, you're beginning the registration process and you're identifying other marks out there that appear to be in use, but are not registered, you need to do some homework to figure out who's got first in use before you're proceeding with that registration. So, first in use in interstate commerce is one of the critical elements when you're going through that registration process. Sometimes you're able to determine from websites or advertisements that may be out there when that other company started using the mark. If you can affirmatively determine that your use was first, you file the registration and you move forward. At least that would be my counsel to that client.
The most famous case in this regard is involving Holiday Inns. You've all seen signs for Holiday Inns, probably stayed at them. Holiday Inn nationally, of course, has a registered trademark. When Holiday Inn found that there was a local operation, a small motel, I believe it was in South Carolina, they sued and much to their chagrin discovered that Holiday Inn had been in existence for at least a decade before the first Holiday Inn of the registered trademark owner, and therefore had prior use. Now, as you indicated in your question, in this case, that was a small operation, a mom and pop operation. We had very local, limited geographical distribution. However, that meant that the national owner of Holiday Inn trademark was not able to stop them. And therefore they had to coexist, even though that might result in some confusion. The law allowed them because they were the prior users. So that does happen. So the short answer is search ahead of time, both the USPTO records as well as Google.
Great, thank you. It looks like that's all we have time for. Thank you so much, Thomas and Kelly. This was excellent content and excellent feedback from all of you. We really do appreciate it. And thank you to everyone for staying on. I know we had a late start, so we appreciate your patience. Again, this webinar was recorded and along with the presentation deck will appear on our website early this evening. You'll be able to find that at community.franchise.org. Thank you very much again to Thomas, Kelly, and the Saxton and Stump team. And again, thank you to everyone for tuning in. Have a great rest of your day and stay safe and healthy. Bye.
Thanks, Lauren. Thank you, Lauren.